Om Tat Sat. Yesterday we had seen on the topic of religion and law in India various factors on some of the clashes of religions and also some of the laws that were formulated either as part of Dharma Shastra or as part of the Islamic laws, and subsequently some of the laws made by the British either under the East India Company or subsequently post 1857. And we had come almost till the stage of partition of India, and also some of the political changes that was taking place, and how religion was also one of the important tools at that point of time to divide the country per se. Before I begin today, there was a minor mistake done by me yesterday when I was speaking about the terminology Hindu. I had said that the original Sanskrit Saptaha was taken in Prakrit to be Haftaha. Shatavdani Ganesh heard and was kind enough to correct me to say that it was not in Prakrit but it was in Persian, because in Prakrit it does not become sir to her. I had relied on another scholar who had written a book in which he had written it was Prakrit. Of course, he was not a scholar on language to the extent Shatavdani Ganesh is, and I'm grateful to Dr. Ganesh for having noted that and corrected me. So it was in fact into Persian, and this also fortifies the fact of Dr. R.C. Majumdar when he says that the word Hindu was completely unknown to people of Sanatana Dharma, and it was a terminology given by the Islamic invaders who came from Afghanistan and who had their language as Persian. So therefore they would call us or pronounce our name or our region as per the dialect that would be available to them in their particular region. So therefore the Persian corruption of the word Sindhu Janaha became Hindu Janaha. So that is one mistake on my part, to which I apologize all of you. Then one more aspect is I had said that most part of the volume of Dharma Shastra was Vyavahara. Achara also has great amount of work, but what I meant was the works on Achara had not changed so much. In any Dharma Shastra, if you take the amount of Achara as well as Vyavahara, perhaps Achara may be more and also Vyavahara may be equal sometimes. But since several prescriptions under the Achara did not see as many changes as that of Vyavahara, the bulk of the text we have, which because of later amendments or the changes that was made in other texts of Dharma Shastra, we find that the volume is more for a person to read on Vyavahara because of so many changes. And it is also quite clear. Our way of life, our regular Achara would not differ and it would be the same. But whereas the contractual relations, the way the society functions would obviously change from time to time. And accordingly, law would also have to take a change. So these changes in the societies, which the law will always have to keep up to pace, would all be found in Vyavahara more than Achara. So therefore, the text, in that context, I had said that the text of Vyavahara would be more. With these two, I would like to begin my today's lecture. Coming sometime in 1939, that is about a decade before the independence was given to India by the British, we see that sometime in 1939, the Governor General was Lord Linlithgow. They, for a fact, had practiced a very, very careful policy to ensure that some of the policies that is applicable to Hindus should not be applicable to Muslims. And Lord Linlithgow was in power from 1939 to almost 1943-44 until Lord Wavell's came. And during that particular league, that particular period, he had ensured some of the factors with which more or a special privilege or a veto was given to Muslim League. And I will show as to how that basically formulated the partition theory. Now, a brief historical background of British as to why they did this. Now, Britishers, after the 1980-57 uprising, realized that if we have to fight Hindus and Muslims together, one time we were lucky in order to subdue them and gain power. Every time we may not be lucky. So they understood that so long as we continue to fight these two people together, if Hindu Muslims come together and fight against British, we will not have too many years to stay and conquer and also to administer this country. So at that point of time, between 1864 to 69, that is a few years after the 1857 uprising, a person called Lord Lawrence became the Governor General of India. By device and by policy, he ensured that there is always separation of Hindus and Muslims. He knew that there is a complete divide on the manner in which these two communities are going to look at it. So what he did, he said to the Muslims saying that look, Hindus have certain grievances etc. on administration and the way in which it needs and things like this. If you start giving it to them, they will ensure nothing comes to you separately at all. So therefore you ensure that you give the support to us. Now we must all realize that Muslims were in minority even at that point of time. Their population was lesser than what it is today in terms of the percentage of the population of Muslims at that point of time in mid part of 19th century. So it is always easier for granting privileges to a small set of people than to grant something to a very large set of people. So therefore they adopted the strategy and they said, we will give you certain privileges only to Muslims. And if you are able to ensure that you will give complete support to us, British and Muslims together can control the Hindus. Now look what had happened. You were in power for a period of 500 years from 12th century to almost 17th centuries. Then afterwards what happened? Marathas became supreme. And you know what was your state when Shivaji was there? What was your status when Peshwas were ruling? You were almost going and dwindling down to a minority and you would lose all your rights. You are made equal to everybody else. You will not be able to have your own religion, have your own thoughts, have your own property as per what is there in the Quranic thoughts. So therefore, you leave aside all of this, you come with us, we will be able to help you. If you go under Hindu rulership, you are bound to suffer, you are bound to lose everything. This was the thought inception made by the Britishers soon after the 1857. So you would therefore realize that the war of 1857 in which several rulers of India, be it Muslims or Hindus, they came together to fight as British, was therefore a stray incident. And never in the entire freedom fighting struggle do we see that these two are always coming together to fight a third enemy at all. And yesterday I also read a quotation of R.C. Majumdar in which he says that for sure when we read the history we come to know that the entire Muslim set never believed that they are part of the Indian unity at all. So giving into that, Lord Lawrence knew this basic fundamental difference between the two religions and he played completely on that particular religion. After Lord Lawrence came Lord Hamilton. Lord Hamilton also aggressively pursued the same policy as that of Lord Lawrence as the Governor General and he also continued. So much so that when Aligarh Muslim University earlier was formed, their principal was a Britisher called Theodore Beck. He gives a statement and he was also the founder secretary of the Mohammedan Anglo-Oriental Defence Association of Upper India, that is all the northern India. And Aligarh Muslim University, as we all know, was made as a reaction to Banaras Hindu University. And it was predominantly a Muslim student organization or a college. Now in 1893 December, he made a declaration. He says in this declaration that it is imperative for the Muslims and the British to unite with a view to fighting these agitators and prevent the introduction of a democratic form of government in India, which is unsuited as it is to the needs and genius of the country. We therefore advocate loyalty to government and Anglo-Muslim collaboration. Now, this collaboration between British imperialists and the Muslims used to be termed by K. Munshi as master races, because Munshi says that they always believed that we are a better race than them and we have come here to rule them. They have no business to rule us, and if in case they were to rule us, we will not be the race as what we used to be. So Munshi writes that this collaboration between British imperialists and master racist Muslims was seen in action when the Muslim delegation staged a command performance and the Minto-Morley reforms divided the Indian people into communal compartments. Now we all know under the Minto-Morley reforms earlier, separate electorate was also taken, and they had said that who would come to vote, who would stand for elections and things like this, and they had recognized that Muslims would be separate electorate, Hindus would be separate electorate, how many seats would be given to them, and so on and so forth. And they go on to say that unconsciously Hindus were moving towards accepting the challenge by developing strength to combat the conquistador spirit. This led to movements varying in goal and technique. This is the inference of Munshi. And at that particular point of time, there were several other leaders, such as Sir Syed Ahmad Khan, who was the leader of Muslim elite. And all these people also supported the very idea that Muslims and British government had to be together. And only when they form together and they start fighting will they be able to have a survival in India. If they are not with British, they don't have a separate survival. This was the thought process. Then we are all aware of the Khilafat movement and Gandhi's response to Khilafat movement. Khilafat movement had nothing to do with India at all. It was not even concerning any region of India specifically. But Mahatma Gandhi believed that by supporting the Khilafat, he would be able to garner the support of Muslims, and these Muslims who will be supporting the Britishers for all facets. Now, if I support the Khilafat movement, they would come and support me. And it ironically, at that point of time, the man who cautioned Gandhi not to go with fanatical Muslims in the Khilafat movement and continue with the nationalist ideology was Muhammad Ali Jinnah. Muhammad Ali Jinnah, by his very nature, was not a fanatic Muslim. In fact, he married a Britisher's daughter and led a very, very aristocratic life. As far as his life and his manner of living is concerned, is not very different from Nehru. And he was as ambitious and careerist, or maybe more perhaps, than Nehru. And as a lawyer, he had a much better standing than Nehru. We don't see Nehru arguing many cases in the court. We don't have judgments reporting Nehru's arguments at all. But we have several judgments and laws being formed on the strength of arguments of Jinnah. Jinnah was a very, very well-known lawyer in Bombay. He was a senior advocate. He was a very, very sought-after senior advocate in Bombay. And many people in Bombay, all nationalists, idolized themselves to be Jinnah one day because of his oratory skills, because of his nationalistic approach. After the Khilafat movement, the Hindu-Muslim the riots ensued in Kerala. There were Mopla riots, and many Hindus were butchered under the Mopla riots also. So the cost of supporting a Khilafat movement was backfired by unleashing terror on Hindus who were asked to support the Khilafat movement. So out of the various mistakes of Mahatma Gandhi, one of the top mistakes would be the Khilafat support of the Congress to the Khilafat movement. And after this Khilafat movement and Gandhi, all of these, if it was taking place in one place and was dividing between the two religions much more, a clarion call was required in order to have a nationalistic spirit. Until that point of time, we see that for the fundamental unity of India, the concept of Brihat Bharata always existed, starting from as early literature that we see of Chandragupta Maurya and Chanakya, and all the way up till to the Gupta period, and subsequently we see in Vidyaranya. All of them had that this entire Bharatavarsha that is there should be under one particular rule. And no matter even if some other king is ruling, they should always ensure that the Bharatavarsha is ruled well and by our own people, and to ensure that Sanatana Dharma is always protected. Now, this was lost after Vidyaranya and to some extent Shivaji, etc. We don't see any major leaders coming on on to say about nationalistic ideas or for nationalism at all. And then there were these Britishers dividing by policy and by design. So during the later part of 19th century, when some of our own men saw the manner in which Britishers were ruling by dividing the two communities, and more so, whenever there was a riot and unleashing of terror by the Muslims, there was no proper response by the Hindus at all. The Kshatra in the Hindus had completely dwindled down, and no nationalistic spirit ever arose. So Munshi writes that there was a counterattack intellectual rise was given by Swami Vivekananda, by Swami Dayananda Saraswati, by Aurobindo. Some of these people, by their very ideas, were able to put some sense in everybody to say that unless and until we have patriotic and nationalistic spirit aligned along with religion, we will not be aligned to go, we will not be able to move ahead. Now, if you read any of the literature of either Vivekananda or of Aurobindo especially, we see that they are very, very patriotic. You come to see how for them religion or nationalism was not very different. In fact, we should read them more for their nationalistic approach than for their sermons on what religion is or what Vedanta is, so on and so forth. So although they were religious leaders, their patriotism is shining very bright in some of their literature. Talking about Swarajya, Aurobindo writes, Swaraj as a sort of European ideal, political liberty for the sake of political self-assertion will not awaken India. Swaraj as the fulfillment of the ancient life of India, under modern conditions, the return of the Satya Yuga of national greatness, the resumption by her of her great role of teacher and guide, self-liberation of the people for the fulfillment, final fulfillment of the Vedantic ideal in politics, this is the true Swaraj for India. Now many did not understand the moment they said Swaraj, that means self-rule. So they said that as long as Indians are governing their own, it is called as Swaraj. Look at the way Aurobindo has interpreted it here. To say Swaraj does not mean that you are holding the political power and will to rule your own country. It is in order to ensure that what is the ideals that is given in the Sanatana Dharma, that you are able to do. And you are able to have your own religion, your own practice, and which is completely in sync with nature. That is actually what is called as the true Swaraj. Now, very clearly, some of these intellectuals' idea of national approach was transformed into mass approach by Lala Lajpat Rai, Bal Gangadhar Tilak, and Bipin Chandra Pal. Now, this Lal Bal Pal, three of them, trio, many of these mass movements, they relied on the intellectual writings of these people, and whatever they had said in writing was to an extent possible put into mass by these three. And therefore we see that for even putting up across all people together for national movements, etc., religion was used as a tool. For example, the Ganesha festival, putting of everybody coming together, making it as a community festival, than just doing a puja at their individual houses, and to have in community the entire Ganesha procession and so on and so forth, would bind many people together. And in that, various nationalistic ideals were also told, so on and so forth, was all invented by Bal Gangadhar Tilak, and so on and so forth. Many people came together. Then subsequently, later after all these people, we also see Tagore writing much. And at that point of time, we also see in Bengal, in the earlier part, Bankim Chandra Chattopadhyaya also writing the famous Vande Mataram and few other literature. Some of these are very nationalistic poets, and many of their writings are also aligned with religion as well as our nation. And in fact, for us, we even worship India, our land, as Bharata Mata. We call her as the Mata, we call her as the God, and we worship her as well. Then subsequently, as Hindu leaders, we also see Savarkar and Hedge were also making their movements very, very briskly at that particular point of time. For a great account on all these, as to how these people movements took place, you all who are all interested may read K. Munshi's Pilgrimage to Freedom. It is in 2 volumes. The first volume is the writings by Munshi, and second volume is certain documents and appendices which has been referred to in the first volume itself. Anyway, for all these movements that had taken place, this is only a historical approach. So there were movements and counter movements, both by British and Muslims on one side and by Hindu nationalists on other side, and many of these had taken place. Then slowly after, in the 1932 Roundtable Conference onwards, because Jinnah was also not given his due in terms of his political leadership in the Congress, and Nehru was also favored. At that particular point of time, several other factors also included that Muslim League confirmed and affirmed Jinnah as their leader, and over a period of time, in a short span of less than about 8-9 years, Jinnah's strength on the Muslim League only grew more and more. There were perhaps very less people to represent Muslim League as effectively as Jinnah, and the divide between Gandhi and Jinnah widened continuously. Jinnah had adopted a particular approach. Whenever he would demand something and it was not accepted and he would be called for a meeting, he would say, I will not attend that particular meeting. For me to come and attend, you have to first agree to whatever points I have suggested, and only on your agreement I would come. So there were several meetings held between several national leaders. Jinnah and Munshi meet, and we also see Nehru and Jinnah meet, Gandhi and Jinnah meet. But what is the final outcome of all these several numerous meetings? There is almost none. And Jinnah, for all part of his effects of Muslim League's control in the Indian government, because in 1939 we were only looking for more special and specific status to be given to Indian representatives. The concept of independence had not arisen in 1939. What happened in 1939? 1939, Second World War started. After Second World War started, and Britain also was deeply involved in this particular World War, time and again they came to Gandhi and they said, you please allow Indian soldiers to come and fight for us in the World War as part of our British regiment. World War I, the Indian soldiers had fought alongside British at that point of time also. World War II, who were already employed or won, there were a lot of other soldiers also who had to come along. So a request was made to the Congress saying, you kindly accept and you send these people so that they could come and they could fight alongside British. To which Gandhi had always said that no, I will not be able to say. The reason for Gandhi not sending Indian soldiers to fight was not because why should India fight for British. The reason was Gandhi believed in non-violence. And as time increased or time passed from what his view was in 1920s and even nearing to 1940s and 47, he had become the apostle of non-violence. So he had an unsurmountable burden on his shoulder to say, anything that I speak cannot lead to violence at all. So there can be violence all around the world, but I should not be the ones who can confirm or assert and say that I confirm violence at any given point of time. So he said that, how can I ask my own countrymen to say you go be part of a particular war when I am saying that ahimsa is the only tattva? How can I support war openly? So therefore I will not be able to support. Jinnah and Congress both saw this as a very good opportunity. They saw that British themselves are losing their power. Their military strength is dwindling down. The military strength of Germany had also increased a lot by then. And Hitler was extremely arrogant in accepting any of the demands. He wanted by hook or crook, because everybody by then, French had their colonies, Portugal had their own colonies, Britain had their own colonies, and Britain was in fact occupying most part of the territories of the world. And when Germany also had its share of better finance and economic reforms, and they were also rich, they thought, why everybody else is also having colonies, why should I also not have a share in it? And the only way to take a share in it is by fighting along other Europeans and taking power. And this had also begun at that point of time. The Indian leaders very clearly realized that if the Second World War had to continue, and as and how the war proceeded from day to day, even 1942-43 onwards, they realized that they would definitely be moving towards Indian independence, because it is very difficult for Britain to have the kind of authoritarian rule on India the way they used to have. So at that point of time, Jinnah made a clear demand and he said that we would want a separate area or a region to which we will be able to rule. So even in Constituent Assembly came much later. He made a demand for a separate rule of separate people of his own. Basically seclusion. At that point of time, Cripps mission was also sent. Just before the Cripps mission, what the Britishers had cleverly done was, even especially by this Lord uh, Linlithgow, what this Linlithgow had done was that as regards the communal electorate as to who would stand, who would have the region, how much seats should go to Muslim League, how much should be with Congress, about the region in which Congress would rule and Muslim League would rule. For all of this, Muslim League had a veto. So unless and until Muslim League, not by the number of, they knew always that if an election was conducted at that point of time in which a share was given to Indians, they said Indian representatives could also be there. They knew that Congress may win hands down against Muslim League, and because they had sufficient number of Muslim leaders within the Congress party. All Muslims are not part of the Muslim League. So they thought if a Muslim League candidate is put, Congress could have put another candidate who was a Muslim from their side and he also could have won. So at that particular point of time, they knew that these people by sheer number, they would be able to say and have a say because they are majority in number, in the number of representations that would be there as against Muslim League. So Linlithgow had very clearly said that if Muslim League, even there can be even 1 seat or 10 seats, it doesn't matter, if they will have a veto power. So Congress was under compulsion to ensure that Muslim League assents to whatever Congress says, and only if they assent will they be able to have their way ahead. Otherwise, no. This was the Britishers' policy. Jinnah took full use of it, and Jinnah said that I would want a separate state. I would want to be ruled separately. Even if Britishers want to rule, you can go ahead and rule Congress and India, but a separate region will have to be given to me, and we would call it as Pakistan. That is land which is very, very pure. That is the etymological meaning of Pakistan. So he said that we want an idea of Pakistan, and they mooted that particular idea. And by 1942, the war had picked up clear pace, the Second World War, and they badly needed Indian support, without which, because population was very high here and all of these soldiers would have really put in too much of a strength on the British end. So Stafford Cripps was sent by Winston Churchill, and they said that you please go do something, negotiate whatever they want, and in that you take their confirmation on them coming and supporting us in the war. And with that intent, Sir Stafford Cripps was sent. The Stafford Cripps proposal was nothing different from whatever the 1940 August also there was a referendum in which certain proposal was sent. These proposals did not mean anything to Congress because what was already existing, they had made only some small alterations and nothing major was even given to India. So therefore they said there is nothing major that has been given here at all. Why did you even come? So Stafford Cripps comes to India and meets Gandhi at that particular point of time. In 1942, Gandhi had started the Quit India movement because they knew several other aspects had taken place. The idea of Pakistan was mooted in the ideas of all Muslims. And because these people were not accepting and Congress was completely aloof to it, and Gandhi was only saying that I will convince my friend Jinnah, he is my brother, I will have to convince him, but he is not agreeing. So on and so forth, dialogues were taking place. They said the only way to ensure that these people agree is by way of riots. So all throughout India, Muslim Hindu riots had begun. One or the other place, it had continued at that particular point of time. And violence was on the go. I'll come to it as to how Gandhi reacted to it a bit later. But at this particular point of time, it is interesting to note that under Quit India movement, as soon as it had started, picked up pace, the Britishers realized that if there is too much of internal disturbance within India, and we are already fighting a war outside also, it will be very, very difficult for us to manage. As a result of which, they said they said that we will arrest all these Indian leaders who are into Quit India movement, and they arrested Sardar Vallabhbhai Patel, Munshi, and Gandhi. All these Congress leaders were all put in jail in 1942 December or so. They were all put in jail. And March 1943, Munshi fell extremely ill, and because of his ill health, he was released. Sardar Vallabhbhai Patel continued to be in Yerwada jail in Pune, and because Stafford Cripps was coming, and it was important for Stafford Cripps to ensure some negotiation and settlement happens, Gandhi was also released. And one more thing that happened at the relevant point of time, I think the king had also agreed to come and visit India. He had to visit Calcutta. So the Britishers were very, very keen to ensure that some sort of a settlement happens and there are no riots or even demonstrations or any other freedom fighting movements held when the king was here. The England king, whenever he came here, they knew that he was only a tutelar head. Everything was held by the prime minister, and they were ruling for the administration. The way the Indian president is as a tutelar head of the government here, same way the tutelar head there was the king. But they wanted to ensure that the visit becomes smooth and they did not have any demonstration. Now, when they were completely in desperate need for some sort of a settlement, Sir Stafford Cripps' mission, when they came, out of all the referendum they had a very interesting aspect. They said that the veto that has been given to Muslim League and to Jinnah would be taken out if in case you were to agree to these demands. But of course, the various demands and benefits that was granted to Indian Congress were some 30 or 40, out of which one of which Britishers agreed to concede was this. All others did not make too much of a difference in us. So when Cripps met Gandhi, by the time the king had come and these people had not even formulated what to answer, and Munshi sees this and immediately writes a letter to Gandhi saying that please don't reject their offer. Look at this one particular thing in which they say that veto given to Muslim League would be taken away. It would really increase our chances of a undivided India at all. And because this man is making a very great claim for a divided India, so therefore you please ensure that you don't send him empty-handed. We will agree to it. The war may or may not run for quite a long time, but we will get an undivided India because they are going to take away the Muslim veto power. What the Congress had demanded is that by the end of this war, if in case we are able to send the number of soldiers from India to there, after the completion of your war, you may win or you may lose. After the completion of the war, you should make India independent in clear terms, and you should transfer power and you should go away. Britishers could not accept that. And when this particular demand was placed in the British Parliament, Winston Churchill was asked very, very specifically. Now there is a referendum received from India that they would want independence. Is British with a view to take this particular support, military support, in a mind to give India its independence? Winston Churchill, in his speech in the British Parliament, says that I am not appointed as the liquidator of Her Majesty's empire. I am not here to liquidate. Why? And he says that India is a very prized possession of British, and no matter what, we will not be able to live. This was the answer given. Be that as it may, that happened in Britain. But by the time Cripps went and met, and Munshi and other leaders also tried to persuade Gandhi to say, we will accept that and leave. But by the time all this could sink in Mahatma Gandhi's mind, he had already met Cripps. And when he asked about the proposal, all that Gandhi had to answer Cripps is, if this was the proposal, I think you have wasted your money in traveling from London to India. Why don't you take the next flight back? Then Cripps said that I shall surely consider that. So it was a complete failure, and they went back, and there were no changes, and the veto with Jinnah continued. And speaking about the manner in which Jinnah and Gandhi had even looked into each other, Gandhi always wanted Jinnah to agree to particular demands and also come to say that, okay, we will live together as brothers. This is what he expected. And they said by coaxing him, he will be one day able to change his mind. We have seen that in various Bollywood movies, that in some people is so good that the other person becomes also good by end of the movie. So Gandhi also expected something of a similar sort. But look at what Jinnah had to say when he was meeting Sir Francis Lowe, he was the editor of the Times of India at that point of time. He asked about Gandhi, and he said, uh, Jinnah claimed special safeguards for Muslims and opposed the very idea of Constituent Assembly at that point of time. Because 1942 they said there will be a Constituent Assembly, you can make your own constitution. That is what the Cripps Commission had also said, saying that by end of this war, you give whatever and there will be a Constituent. Then they started the Constituent Assembly also. They said after the war, we would start a Constituent Assembly where India would have its own constitution, you can draft your own constitution. But whether there would be transfer of powers, there was no clarity in 1942. But they said that Constituent Assembly would be there. Jinnah said, I don't even want this Constituent Assembly, I want a separate state. And he said, I wanted special safeguards, and he opposed the very idea of Constituent Assembly. In this interview with Lowe, Jinnah characterized Gandhiji as the biggest Hindu in India. This is how Jinnah saw Gandhi. He did not see him as a bridge between Hindu and Muslims. He saw him as the biggest Hindu with whom I can never be together. I am completely different from what he is, and I cannot continue to do so. And looking into this, say what K. Munshi writes, to many of the master races, that is Muslims, who are gathered under the leadership of Muslim League, Pakistan was not a goal. It was a step to gain a solid base from which to conquer Hindu India, as their imaginary ancestors had done, if necessary with foreign aid. It was a price that was demanded of the nationalists if India had to secure freedom from British rule. The choice before nationalist India was between the devil and the deep sea. So they said, Munshi very clearly, he was a visionary, and way back then he says that all that this Muslim League people wanted was not to say that you give our state, we will be up to ourselves and we will govern a particular country to ourselves and we will be happy with us. They wanted Pakistan to ensure we have a complete state power, and with that state power we will come and again conquer India. And this is precisely what they did after independence also. Immediately after Pakistan was formed, they did not look at themselves governing. Even to this day, they are not happy governing themselves. As soon as they wanted to acquire Kashmir because it was an independent state. At this point of time, with this mindset, after 1942 especially, there were widespread riots all over India. And look at how British looks at this mob riots. For the Britishers, this was not a riot between two religions, and no special law was made for religious riots. Britishers did not do. At least in independent India, till date we do not have specific laws to manage religious riots at all. A riot on the ground of it may be a caste issue of a riot, or it can be due to corruption, there could be a riot, or there could be any other political scenario or a situation in country to which there may be a riot. Riot can be of different nature and of different types. Religious riot is also placed in the same footing. There is a riot, and riot would have to be controlled. For British, religious riot meant that it is a riot only to overthrow law and order. And anyway, it has continued even to this day. Then what happened? Religious riots everywhere happened, and at that point of time, Gujarat mainly was consisting of several of these merchant Hindus who were happy doing their own trade, and they did not even interfere in anybody's life. They were happy, left to them, I will do my trade, I will have this. At that point of time, there was a congressman in Gujarat called as Bhogilal Lala of Gujarat Congress. His family and his own people or the community in which Gujarat Congress was there, also came under several and severe attack from the Muslim League movements or from Muslims per se because of the Hindu-Muslim riots that had ensued. At that point of time, Bhogilal Lala writes a letter to Gandhi saying that my own family is getting butchered, many of our women are being raped, and many of our properties are being unleashed. Kindly let us know what to do, what is the step that I need to take. All my life, I have led by your principle of ahimsa, and if this is what I have to get because of ahimsa, what else I am supposed to do? You tell me. There are many akhadas in Gujarat where people go, the Vyayama akhadas, etc., where people go and so on and so forth. These akhadas are also quite here and they are able to help. Can we take their help and put some resistance by force? I think unless and until we use some resistance by force, these are not people who are going to go away. So what is the action that I am supposed to take? is a letter written by him to Gandhi. Gandhi replies to Bogilal Lala saying that ahimsa paramo dharma, you are not supposed to do anything. As far as possible, try to save your people. If you can't save your people, submit to them. They may kill. After all, Atma cannot be killed. It is only the body that can be killed. They will kill you and they will go, but your eternal spirit will live not for you, but for your for your forthcoming generation, who will be able to appreciate your sacrifice and they will be able to continue. Bogilal Lala did not know of any answer. Then he also goes to Sardar Patel, Munshi, so on and so forth. It is his story. Leave it. After looking at these particular letters, in sometime in April of 1943, Kanailal Munshi becomes very, very upset with this particular approach. And he writes to Gandhi and he says, look, when somebody is not doing anything on our own, we should not hurt others. This is ahimsa. We also agree with it. But if somebody is coming at your doorstep and trying to kill somebody as a part of self-defense also, if you are not trying to take up arms, then it becomes extremely difficult. What do I do? And then Munshi goes and tours several of northern India in parts of Uttar Pradesh and Haryana, Punjab, Western Punjab, parts of Bihar. After touring all of this, he hears first person accounts from people who have had, who were sufferers of several riots and who had practiced ahimsa for all their life, believing in Mahatma Gandhi. And after listening to all of them, he writes their entire account to Gandhi and he says that I have gone through all of this and I have personally seen their own sufferings. Even after looking into their sufferings, I don't think we should be advocating ahimsa. You please change your stance at this point of time, because I am unable to continue and tell everybody saying that what does Gandhi have to say. Everybody would go to Munshi and say, what does Gandhi have to say in a situation like this? Please guide us. So he says that people are asking for your guidance. You have to tell them that if somebody is killing you, there is nothing wrong in taking up arms, and this is what I strongly believe. Gandhi says that this is all what you strongly believe. You please leave Congress and go. As long as you are in Congress, you have to go by ahimsa. If Congress only advocates himsa, even at the cost of self-defense, then what are we going to achieve? You please leave Congress. When he hears Gandhi says this, Munshi almost breaks down and he says that all my life I have been your ardent follower, and if you are saying I have to leave Congress, let me think about it. Then he goes, consults his family and also meets Sardar Patel and he says, Gandhi said this, what do I do? Sardar Patel says that it is your deep conviction that you are not supposed to continue to be subjugated by the onslaught of other community, and that is not your definition of ahimsa. And if Gandhi for your principle says that you have to leave Congress, I think you should leave Congress. So Munshi quits Congress and forms Akhand Hindustan campaign. Akhand Hindustan means undivided Hindustan. The entire Bharatavarsha should be one, and he makes it as a movement. As soon as this movement begins, many Congress leaders who also thought of and sided with Munshi's point of view, everybody tells him saying that okay, we would also leave Congress and we would also come. This news reaches Jawaharlal Nehru and Patel and Gandhi and things like this. They are all called for a private session with Gandhi, and thereafter, after that particular session, Munshi says, I don't know what happened. They come and say that sorry, we will not be leaving Congress, we will continue to be at Congress, and they continue. And there were movements of Hindu Mahasabha, and there are movements of Savarkar, who was part of Hindu Mahasabha and RSS and so on and so forth. And they try to keep the riots in check. Hindu Mahasabha is also there, who says that no, if somebody is hitting you, there is no point in stopping, we will have to stop. And what happens? People slowly stop following this Congress ideology of ahimsa when there are riots happening in your own area and your own people getting killed. And Gandhiji's ideology of ahimsa is not going to do any good. Slowly the Congress loses its own shine, and the riots continue a lot. Many people get killed in Bengal and also in Bihar and so on and so forth. And in Bihar, the Hindus do not stop. They uprise and they start slaughtering Muslims again as part of the riots. And when Bihar, there is a rampant killing again, or defense and a give back retort by Hindus to Muslims. Jinnah comes and says that Hindu Muslims are brothers, why are you fighting? Please don't fight. We are all made to be good and living with each other. And the riots to some extent go down. Then thereafter we see at the same point of time, the formation of Indian National Army by Bose, and they come and they unleash an attack on the eastern part of India, and they try to acquire against the Britishers. At that relevant, after that, the INA trials also many people know here. After the INA trials are complete, there was a naval uprising. Naval uprising was by Indian soldiers in the British regiment themselves. That there was a naval uprising, and the episode of Komgata Maru, that particular ship, that also had happened. By virtue of all these, they realized, even the Congress realized, that this Ekashruti of Ahimsa is not going to help us in any particular manner. And by virtue of which, the Congress said that, okay, Gandhi is separate from Congress. Gandhi has his own ideal. He is a prophet. But Congress, for all practical purposes, say after the national uprising, all naval uprising, etc., they also changed their stand and they said we should also have Ahimsa only as a part of self-defense. But they were the last to make that change. And by then, Britishers had also realized the decline of the shine in the Congress and the support thereof. And the members of the Hindu Mahasabha and members of the Muslim League, members of various other political parties were also consulted for the purpose of making this Constituent Assembly, or the manner in which this had to be held, even for political movements, etc. Then we see, as part of law to be made, Constituent Assembly came into picture. The reason why I gave this entire political background is because law, if you look at law in complete vacuum to what had happened politically, we would not get a complete idea as to what was being written and why it was being written. When you have this some bit of a historical background as to what was happening in the country, you would know as to how these particular laws were made. Now, Constituent Assembly, the Britishers said that immediately after the war, the Constituent Assembly would begin. And true to their word, Constituent Assembly began. In 1946, they said who are all the members who would be taken, and they had their own list of members who from Congress who would be there, independent who would be there, from Muslim League who would be there, all others, they had their own list of people who would participate in the Constituent Assembly. Jinnah even at that point of time said, what is this Constituent Assembly? You are trying to make a constitution for us in which we will also have a say, somebody else will also have a say. I am not agreeing to this unless and until you say for sure that I am going to have a separate state. And in this particular separate state, why should I sit with you to make my own constitution? You first form a state, transfer the power. Whether we want constitution, whether we don't want constitution is something for us to see. So I don't want to be part of Constituent Assembly. But several other Muslim League leaders also said that, okay, until that separate region is given to us, we will participate in this Constituent Assembly. Now we see in the proceedings of Constituent Assembly, the Constituent Assembly debates are available. If we look at the debates, there are several Muslim representations, but they are all Muslim representations within the Congress party or from other political parties. Muslim League would come, they would boycott the session, they would go. They would have some slogans, they would shout some slogans, they would go. We don't see Jinnah even coming once directly to Constituent Assembly, except for maybe the first time, and having any worthwhile contribution in the formation of the constitution. Of course, he was a great lawyer. He knew law very well, and also in administration, and he knew politics extremely well. He was the right man, but he was very, very clear that I don't want to be part of this constitution. But in our Constituent Assembly, when they started, many others from the Muslim League who also were present, they said, even in India, because they said we are going to be Pakistan, India, etc. What is the region? There were separate commissions being issued by Britain who would come and formulate and say where would be Pakistan. So there was East Pakistan, West Pakistan, Bengal also had to be partitioned. Congress leaders themselves mooted that Bengal, there is no other option but to have into two. None other than Acharya Kripalani also said from Madras, saying that no, I don't think there is any other option but to divide Bengal into East-West Bengal or North-South Bengal, in which two had to be there. And there was also confusion on whether Lahore would be part of Pakistan or be part of India. And our leaders, national leaders, they all said, some of the Congress, but important national leaders said, it would be unfair on our part to ask both Lahore and Calcutta, Delhi, all major cities only to India. Should they also not have certain good cities? I think Lahore should go there so that they are also happy. Nehru in fact also says that there is one red fort in Delhi, one red fort in Lahore. If both red forts are in India, I think I will be doing a lot of injustice to my Muslim brothers. So let them also have a red fort there. I will also have a red fort here. But how much was the percentage of Hindu population in Lahore? How many of them would actually have to suffer? On these lines, nobody thought. They thought they are sitting in their father's house, trying to partition some of the gold and silver jewelry to say how much each son should have. This is the kind of division that they had in mind. Be that as it may, in this constituent assembly, first the Muslims, even members of the Muslim League, etc., when they came, they said that you please make two different constitutions. One for which Hindus, it would be applicable to Hindus, and for other religions who would want to side with Hindus. And two, you make a separate constitution only for Muslims. So at the very beginning, on the very form of constitution and the number of constitution, there had to be a debate to see whether there should be a single constitution, there should be two constitutions. They said that, sorry, we will not be able to do this. There will be only single constitution. What are your rights and privileges? We will see. The moment they said that there is going to be only single constitution, the members of the Muslim League as well as other Muslim representatives, they said, all right, you are not making two constitutions, you are making only one. We will do one thing. You will have certain rights, we will also have certain rights. What is the essence of Quran and the Hadith that is there? We will formulate it and we will put it in our part of the constitution which is applicable to us, and your part will be applicable to you. Ambedkar said that, sorry, it is not possible. If that is so, we could have had two different constitutions only. If the law is there, law will be applicable to everybody. And throughout the Constituent Assembly debates, we see demands being placed even after, during the session of Constitution itself, partition took place in 1947, and many members of the Muslim League were deleted from being members of the Constituent Assembly because they all went on to form Pakistan. And many of them who continued to stay in India continued to attend under different political parties, including the Congress. They would come and say, demands were being made in the formation of constitution for Muslims separately. They said, on law of property, etc., Muslims can have their own this thing, you please write that in the constitution. Or every administration, the manner in which we are going to say, you please write that in the constitution. What should be some of the fundamental rights apart from whatever you have given, some are our own rights, that should also be there, you please write that in the constitution. The demands made are not one or two. Of course, people now, when they look into the constitution, they say your religious rights governed under article 25 to 30 of the constitution are very, very non-Hindu in nature. It supports Muslims a lot, it supports other faiths a lot, so on and so forth, is the general criticism on the people who actually wrote constitution, and more so on Ambedkar. They said, why did they have to give a special article 29 and 30 cultural minority rights for them? If the same rights were given to everybody, they also could have enjoyed, we also could have enjoyed. But by giving them special rights, what it meant is we have been taken away our rights. How those judgments have passed to come and see, we will see it later. But this is the general criticism. But one should stand in the shoes of Ambedkar and see what was demanded and what was given. From a standpoint of asking, I want the entire constitution to be given, Ambedkar was able to negotiate and give them only 2 articles or 5 articles. And out of those 5-6 articles also, so 3 or 4 is generally applicable to everybody. How it has taken shape by virtue of judicial precedents in the country and how the law has been interpreted is not Nehru's fault. Sorry, it is not Ambedkar's fault. It is the fault of subsequent politicians, subsequent governments, and some of the judgments that came into picture. We will see some of the laws that were being made and how they used the constitution to support them. But to say that Ambedkar was responsible for having a few articles in for cultural minority rights, I think would be very, very unfair. But for Ambedkar, we would not have had so much of clear fundamental rights which is uniformly applicable to everyone in India and not specifically only to one particular community, and to that we should have our gratitude to him. But even before this entire constitution had taken place, way back in 1935 itself, the Britishers thought of making a Government of India Act. There was several Government of India Act. There was one of Government of India Act 1919, which was replaced by Government of India Act of 1939. Then after 1939 Government of India Act, most part of the Government of India Act 1939 itself became part of the Constitution of India as regards the formation of the government. Now, before making this 1939 Government of India Act, they said there should be one single constitution for the entire country. And to that extent, they appointed one person called Lord Bryce. And they sent Lord Bryce to say, you please go visit India, look into their, you also know their history, you look into their history, you visit the entire places, have dialogue with them, and you please write a report to us on what could be there on the common constitution to be placed. Lord Bryce makes a complete visit, goes on to meet several people, looks into the law that were already in place, and after all this, writes a report. This is the Joint Committee report on Indian constitutional reforms, which was headed by Lord Bryce. In 1935, look at the Britishers' assessment of India. They were asking if India could also be run on a Westminster model. Westminster model is what we have now, the Lok Sabha, Rajya Sabha, the upper house, lower house, and the unitary and federal form of government, all of this in the Westminster model as to how it could be run. Can India also run on this? Was the question asked. This is what he answers in his report. Parliamentary government, as it is understood in the United Kingdom, works by interaction of four essential factors for the democracy to function. What is it? The principle of majority rule. Number two, the willingness of the minority for the time being to accept the decisions of the majority. 3. The existence of great political parties divided by broader issues of policies. 4. Rather than by sectional, third one is the existence of greater political parties divided by broader issues of policy rather than by sectional interests. And 4, finally, the existence of a mobile body of political opinion owing no permanent allegiance to any party and therefore able by its instinctive reaction against extravagant movements on one side or the other to keep the vessel on the even keel. In India, none of these factors can be said to exist today. There are no parties as we understand them, and there is no considerable body of public opinion which can be described as mobile. In their place, we are confronted with age-old antagonism of Hindu and Mohammedan, representatives not only of two religions but of two civilizations, with numerous self-contained and exclusive minorities, all a prey, P-R-E-Y, all a prey to anxiety for their future and profoundly suspicious of the majority and of one another, and with rigid divisions of caste, itself inconsistent with democratic principle. It is impossible to predict whether or how soon a new sense of provincial citizenship, combined with the growth of parties representing divergent economic and social policies, may prove strong enough to absorb and obliterate the religious and social cleavages which thus dominate Indian political life. Meanwhile, it must be recognized that if free play were given to powerful forces which would be set in motion by unqualified system of parliamentary government, the consequences would be disastrous to India and perhaps irreparable. This is what he says, and in correct assessment of what would be the parliamentary form of government if in case it is given, there would always be fight. Anyway, this joint committee report was there in place. The Government of India Act in form was adopted, but nothing major was changed. Now there are certain criticism to Indian constitution, the manner in which it was drafted, and one of the major criticism was that the constitution is not adequately Hindu. They say that this particular constitution, the way it was drafted, was for a secular India. That is, Gandhiji had also said that if Muslim League wants to take over Pakistan and if all Muslims want to go there, they are free to go there. But I cannot say the same to India. Whoever of whichever religion want to be here, they can be here. Muslims have the choice either to be here or to go there. This in one way was good, that because everybody who wants to adopt and they would have to lose their own land here, lose their own life if in case they don't have to stay. So therefore, whoever wants to stay can stay wherever they are, and that way for peaceful coexistence it was necessary. But Pakistan was not how, it was not how Pakistan viewed this entire scenario. They were happy saying, we have our men here and we have a government there. Having a government there, if in case we have to unleash an attack on India, we will be able to get some or the other support in one or the other form with our own men here. How many of them supported them later, how many of them did not support them later, is for political commentators to comment. But this is how they viewed that particular situation, is all that I can say. And anyway, they moved there. And it perhaps is quite a shocking and a surprising element that most of these national leaders, even when they agreed that by virtue of partition, northwestern province of Punjab, West Punjab, northwest from front province, West Punjab, as well as the area of Sindh would go to Pakistan. Bengal would be also partitioned to say this will be East Pakistan, and 2 separate states would be given to them. And here they said that, see, when you happen there, Hindus may be in minority in that particular portion, and Muslims would be in minority in this particular portion. You wanted a separate state, we have given you. You want to rule by Islamic rule, you please rule there, I have no problem. But you ensure that some protection is given to minorities. But this was only an oral request. Even the legal documentation by virtue of transfer of powers or the Indian Independence Act was drafted by the British, and it was transfer of powers happened. There was no clause for Pakistan to say the minority shall be protected. Their particular personal laws would have to be given effect to, and to what extent they should be protected. These kind of protection clauses did not exist. But in our constitution, in the Constitution of India, they said that okay, we will recognize these rights, and we gave them the rights. Whereas there, no such rights was even given. It is called as the Islamic Republic of Pakistan. Their constitution would also say we are Islamic Republic. That means we may have a law of the land, but if something is said in the Quran and Hadith, that will overrule this. Here we would say no matter what your religion is, if the constitution says particular thing, your religion will have to align with our constitution. If your religion do not align with the law of the land, then sorry, you cannot practice that part of the religion. So therefore there is always a clash in India between what is the religious practice and whether it could align with the cleavage granted to it under law or not. And we see how it has taken part. No matter. The constitution, one of the major criticism given to it, especially by people of the Hindu Mahasabha and also several other people here, was that the constitution was not adequately Hindu. What amount of constitution, even various other scholars including Dr. P.V. Kane has also criticized on this, and recent scholars including Shatabdani Ganesh and various other scholars have also commented and said that what is Indian in the Indian constitution? This particular constitution could have been the constitution of any civilized country. What is so Indian? If you look at the constitution, it does not seem like we are writing a constitution in which we recognize several aspects of Sanatana Dharma here. Several age-old practices of ancient India which we cherished and which nourished us for several centuries, how that would become part of our constitution, this thought process has also not gone into. The word dharma, as I was explaining yesterday, cannot be put into a smaller bracket and said that when I speak of religion, that would encompass the various vicissitudes of the terminology called dharma, because it is very, very encompassing. Why did we not use the very terminology called dharma in the constitution? It is not that our constitution, although written in English, does not use any non-English words at all. For example, Panchayat Raj, is Panchayat a English word? It is not. When we talk about several other aspects, if there is no proper translation available, we borrow that very particular word or a terminology from that particular language so that the meaning is not altered and we understand that particular meaning. Even to this day in law, there are several Greek and Latin terms that we use. In fact, except law, I don't think there is any other segment in the present day that we uses so much of Greek and Latin terms. We are all taught law by Greek and Roman and Latin terms only. So we have, like paripasu, that is several Latin literature, Greek literature, part of the phrases in order to denote the exact same ideology, even written in our constitution. If that be so, why would we not use the word dharma? Why would we not use that? Dharma can also be justice. In the preamble at least we could have used. None of this is used. This is a major criticism. Anyway, the criticism has not been answered anywhere. Plus, even when we look at the Constituent Assembly debates, it is also quite surprising that none of these members of the Constituent Assembly debates even mooted this idea of including some of these terminologies there or aspects of the Sanatana Dharma into the constitution in a way it could be formulated. It is not that I am saying that some parts of every parts of Achara should be put. We will talk about Brahmopadesha in the constitution. No, we are not on that. That there are certain essential features of the Indian culture which is clearly conspicuously absent in the Indian constitution. Should there not be at least a dialogue? Should people not have mooted this particular idea? You could have spoken about it, had a lengthy dialogue over it, debated over it, and then you would have dropped it. No problem. But the fact remains that it was not even mooted and spoken at all, even in the Constituent Assembly. We don't see such things being spoken, even while speaking about the fundamental rights or so. Now, coming to our Constitution of India, the aspects of religion are mostly covered under 6 articles from Article 25 to Article 30. Now, what does Article 25 say? Article 25, these are all under the chapter of fundamental rights. Now, fundamental rights are those rights which are very, very inherent for every human being, and in that several aspects are covered. For example, right to equality is one aspect. Right to freedom of the 7 freedoms that we have: right to freedom of profession, occupation, right to freely move around India, speech and expression, all of these covered in the one. Right to life and personal liberty is covered. Right against exploitations are also covered. All of these are covered under separate subheadings. So under that right to freedom of religion, there are a set of articles. Article 25 speaks of freedom of conscience and free profession, practice and propagation of religion. What does it say? Subject to public order, morality, health, and to other provisions of this part, that is, other provisions of fundamental rights part, all persons are equally entitled to freedom of conscience and right freely to profess, practice, and propagate religion. This is the provision of a particular right under the law. So here they say it starts with a word called subject to. That means whatever right I am going to say further is all subject to certain restrictions. What is this restriction? For public order, except for public order, morality, health, and other provisions of this part. Now, other provisions of this part is, if any of the actions, when you are asserting a particular religious right under Article 25, if it goes against any right given to a particular person to practice profession, if it goes against the right of equality which is under Article 14, if it were to take away life under Article 21, then you cannot assert your right of religion. Only if your right does not come in conflict with any other fundamental rights, only then can you assert your religion. Otherwise, it is very easy for somebody to say, my religion says that a non-believer should be killed, so it is my religious right to kill you, and I am protected by the constitution. No. So therefore, subject to your other rights specifically, certain rights have been given to you, which is there in Article 25. Now they say, what is these rights? They are given in 2 categories. One is freedom of conscience, and the second is right freely to 3 things: to profess religion, practice religion, and propagate religion. Each of these words have been dealt in detail in several judgments. When I am talking about some of the judgments, maybe perhaps tomorrow, I will be able to cover some of these, so I will not go on theory. But most importantly, what is neglected in several of these judicial precedents, but what is very, very important that was recognized in our Indian constitution, which we seldom see in other constitutions of the world, is freedom of conscience. Now, conscience is much more basic and even more innate than any other religious freedom. Now, what is conscience? Conscience is that term which can relate to a philosophical approach of a man, diverse from the idea of religion. While religion mainly bases its existence on the belief system of a man, the conscience is the quality of mind which inquires into the beliefs and facts. So while belief system could be individualistic in nature, conscience relates to a philosophical approach of life which would have universal application. Now, most of us, when we speak, we are all exercising our freedom of conscience without us knowing that it is actually freedom of conscience. Now, religion makes you to believe on a particular faith, on a particular thing, on an existence of a particular God, or believing that a particular scripture is divine and I shall not question it. That is to some extent a part of religion. In India, there can be a person who is atheist, who need not believe in the existence of any God, but still may have his own philosophical outlook towards life. Where does he draw that particular power? He draws from freedom of conscience. Now, philosophy, which is unlike religion, inquires into certain basic questions which can be on our existence, on our purpose of life, our goal of life, etc. Professor M. Hiriyanna very clearly remarks that philosophy, taking in its widest connotation, has its origin in an awareness of our ignorance, and that its purpose is to discover such knowledge as will remove or at least reduce that ignorance in some measure at least. So, which just clearly shows what is the very nature of philosophy. Then they say, but however, this should not be understood as science, because science is also different from philosophy. The object of science is also to dispel ignorance concerning the condition of life amidst which we live. But the object of philosophy is to find out the ends, or the ends of which, in the ultimate sense, we ought to live. So, in pursuit of that philosophy concerning life, a man may take different approaches. And in these different approaches, we see that in every individual, every approach he may have for his own methodology or inquiring into the ultimate truth, he has and he draws his power of freedom of conscience, which was recognized and granted in the Indian Constitution. Now, after part 1, that is clause 1 of Article 25, which speaks of the right to freely profess, practice and propagate religion, clause 2 says, nothing in this article shall affect the operation of any existing law or prevent the state from making a law on religion. On what aspects? Look at this. Regulating or restricting any economic, financial, political or other secular activity which may be associated with a religious practice. So, the clause 1 said, you have a religious right, you can profess and practice or even propagate religion. But this particular, that does not mean that the state cannot make any law on religion. They can make a law. But that law has to be on what? It can be on economic activity. That means if you go to a particular temple and there are funds involved, if there is money involved in that particular temple, and what the temple is going to do with that particular activity becomes an economic activity. It is not a religious activity. The state cannot say how you are supposed to run the ritual in this particular temple. That is not for the state to say, it is left to you. But with that particular money which you have received as donation, what you have to do, the state will have a say, that is economic activity. Then number 2 is financial, political or other secular activity. Political or other secular activity if you try to do. For example, you want to feed about 1,000 people by virtue of some particular festival. There is a political and a secular activity there. You want to use certain other say cultural events etc. to place by virtue of a particular festival. That also becomes some sort of a secular activity, because you are doing certain arts. Art is a secular activity. Anybody can do it. It's not a religious activity. So therefore, state will have a say in that, and they can also make a law there. Then it says, nothing also stops the state from providing for social welfare and reform or throwing open of Hindu religious institution of a public character to all classes and section of Hindus. So if you say that this particular Hindu temple is meant only for this caste, the law can be made to say that, sorry, you would have made the temple applicable only for this caste, but I am going to throw it open to everybody. So one particular caste will come and say, this is my God, I want to go. They will say, you can't stop other castes from visiting it, I will allow. Or a particular denomination saying that only so and so should go, the state can say, no, everybody else can go. So to that extent, laws can be made, is what is the provision given under Article 25. And thereafter they go on in other. Article 26 speaks about freedom to manage religious affairs. This is subject to public order, morality and health, same 3. Every religious denomination of any section thereof shall have the right to establish and maintain institutions of religious charitable purposes, to manage its own affair in matters of religion, to own and acquire movable, immovable property, and to administer such property in accordance with law. Looking at it, it looks very, very clear to us that every religious institution has been given clear right. You can make your own religious institution, charitable institution, have matters of religion, you can manage your own affair, acquire movable, immovable property, administer, all that. But the catch point is not in what is provided. The catch point is in the first aspect. They say every religious denomination or any section thereof. Now, I'll say some of the judgments tomorrow to say how the courts have interpreted religious denomination. Now, for you to be a religious denomination, you should accept that I form part of a particular denomination. Now, Muslims can very well say we are all under one particular denomination. Christians can say we are a denomination. Parsis can say we are a denomination. Jains, Buddhists can say we are a denomination. How can Hindus say we are a denomination? Shaivites can perhaps say we are a particular denomination. Vaishnavites can say we are a denomination. There was a judgment under which they ultimately Ramakrishna mission, they said we are a separate denomination. We are not like any other Hindus. So Ramakrishna Ashrama people are a separate denomination. They got it fighting for something. Anyway, that's leave it apart. A particular person who says that I am a Dvaiti or a Advaiti is not a denomination. Because being an Advaiti doesn't mean that you are a Vaishnavite, not worshipping any of the cult of Vishnu, avatars, etc. We do. So what cult, so majority population of the Hindus do not come within the purview of this word called religious denomination. Only for them, so for people who have this religious denomination, these four apply. They can manage institution, establish institution, have its own matters of religion, they can own immobile, movable properties, all of this will apply. Then Article 27 speaks of freedom as to payment of taxes for promotion of any particular religion. That is one. Then 28, freedom as to attendance at religious instruction or religious worship in certain education institution. On what no religious instruction shall be provided in any educational institution wholly maintained out of state funds. This is the first article. So if state is maintaining a particular school, you cannot be preaching anything connected to religion there because it is a secular activity. But clause 2 says, nothing in clause 1 shall apply to an education institution which is administered by the state but has been established under an endowment of trust which requires that religious instruction shall be imparted in such institution. So a particular trust is there. You have certain trusts in and around Bangalore, in fact Basangudi only, which say that we are a religious trust doing so on and so forth, and we shall also form a particular educational trust. And if they receive certain grant in aid from others, that nothing will apply to them, so they can form. Then clause 3 says no person attending any education institution recognized by the state or receiving aid out of state fund shall be required to take part in any religious instruction that may be imparted in such institution or attend religious worship that may be conducted or in any premises attached thereto unless such person or if such person is minor or guardian has given his consent thereto. So if a child is attending a particular school in which it is very clearly said that the school is formed by a particular trust which is a religious trust. So say for example Sringeri Mata is running a school. In that particular school they say this is run for the purpose of the imparting of regular secular education along with religious education. So I will be teaching kids Bhagavad Gita. I will be teaching kids some parts of the Veda mantras. I will be teaching kids say some other aspects of our religion, and they want to run that in that particular school. And if they were to receive any funds from the state, and if a particular kid comes and says, I don't want to be part of this Bhagavad Gita because I'm not interested in this particular religion, but I want to study in your school, you cannot compel that child to say, take it or leave the school and go. That particular individual right is also existing in that particular child. Despite being in a religious institution, they can get admitted, but they can still be separate and distinct, and they can say, I will not form part of the bigger herd. Then, apart from these religious rights, two other specific rights were given to minorities. Article 29 and 30, they said cultural and educational rights given specifically to minorities. Now, under a constitution, two minorities were recognized. One is a linguistic minority, another is a religious minority. What is a linguistic minority? As we all know, country was after partition of 560, three princely states were there. Thanks to Sardar Vallabhbhai Patel, we were basically formed, and all these princely states were taken together, and you know the 18 states and subsequently number of states that were formed in India, so on and so forth. Now the formation of each of these states were on linguistic basis. So they said, although we have made formation of states on linguistic basis, not always had that particular region always been dominated only by one particular language. We have also seen in history that in several kingdoms there was no one state language at all. For example, in Vijayanagara kingdom, Telugu was the language, Kannadigas were also there, Tamil were also being spoken. You take any kingdom for that matter, you don't see that the entire kingdom was only speaking one particular language. So therefore, Kannadigas we say that Vijayanagara is our kingdom. Telugus they also say Vijayanagara is our kingdom. Parts of Tamil Nadu say Vijayanagara is our kingdom. Cholas you go and say parts of Kerala they will say it's our kingdom. So language was never a an ingredient to differentiate on what is this particular state up to, or whether the state or a political area is covered by so and so language at all. It is for the first time after independent India that India, for all the divisions that are already in place, one more division was introduced, which was linguistic. Now, although they made for the purpose of formation of states that there are linguistic states, many people speaking several languages existed in our own states and other states. So they recognized this and they said, these people may become a linguistic minority there, and they may be bullied by the majority speaking language of that particular region, and they may say that I won't allow you to teach your language at all in schools, etc. How much ever you want to teach at home, you teach, otherwise you will not get anything. So some protection should be given to them. That's why they recognized linguistic minorities' rights, and religious minorities, of course, was existing. Now what does it say? Any section of citizens residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. No citizen shall be denied admission into any education institution maintained by state or receiving aid out of state funds on grounds only of religion, race, caste, language or any of them. This is Article 29. 30. This is the main article. Right of minorities to establish and administer education institution. All minorities, whether based on religion or language, shall have the right to establish and administer education institutions of their choice. Then it further says, the state shall not, in granting aid to education institution, discriminate against any education institution on the ground that it is under the management of a minority, whether based on religion or language. This was how it was existed in the original constitution. Later in 1979, there was an insertion. Why that particular insertion was there, I'll come to it, and I'll also read that article and say how it was taken ahead. Now broadly, these were covered under the fundamental right. There was one more article under Article 44 called as Uniform Civil Code, which also existed under the Constitution. Now Article 44 is under Part 4. These rights which I just now read is under Part 3. Part 3 is fundamental right. Part 4 is directive principles of state policy. They are two sides of the same coin. What is directive principles of state policy? These are only directives given by the Constitution to the government of either India or to the particular state, saying that look, as of now our country may not have the infrastructure or the political wherewithal in order to withstand to say everything would be a right. We want so many rights. Few rights are fundamental. Right from the very beginning of independent India, this would exist. But there are few rights which we cannot say right now, but it is due, you are duty bound as a state to ensure that you would give. The day you are able to ensure that what is only a duty to you can be given as a right to a particular citizen, this can flow from directive principles of state policy to fundamental right. What is that? Say for example, right to work. Can you today approach court or the government and say, I am unemployed, please employ me? I want work? No, you cannot. But government has been given a directive to say, ensure there is no unemployment. That is your right to work under Article 41. They say that it is a right recognized, but you cannot go and claim it as a right because it is only directive principles. Similarly, Uniform Civil Code, they said, is a directive principles of state policy. You shall ensure to see that everyone in India have a uniform civil code. That is, what is civil code? On matters of, it may be on land, or it can be on property, or it can be on several other marriages, etc. They should all be governed under a common law. That is uniform civil code. So that you shall try to achieve. I know today it is not possible to achieve because we have just had partition, we have just had riots, we have just had people killing each other, but you will strive towards it. and one day you would be able to achieve a uniform civil code, was why Article 44 came. Then came Nehru government. They said that okay, we will try to do something for uniform civil code. What do we do? They said if we can have a particular common law for everybody, because the judicial administration was something that we borrowed from Britain and we had it. And as I was already telling earlier, judgments even on several personal laws that I told you had to be given by looking into various for texts of Dharma Shastra. Now, people even sitting in the Privy Council, when there was an appeal possible from the federal court here also, it used to go to Privy Council. Judges who had never known what is a Dharma Shastra, they would have to sit and read and understand what is Hindu law, and they would not know Sanskrit because most of the Dharma Shastra was written in Sanskrit. In whatever little they could understand, the way they would interpret their own laws, they would interpret and write even judgments on Hindu law. But there was a necessity for codification is what they thought. But while codifying the laws on property, marriage, succession, etc., the Nehru government thought that okay, we will codify. Obviously, there was a great furor and said, how could you come and codify all our personal laws? So Nehru said that okay, we will not ask Muslims, Christians and other people to first come and be part of this. If we codify Hindus and we say that as Hindus see, look, we have already codified, that will be some sort of a compulsion on them and or a persuasion to them to say, you can also come into the same fold and later we can have. With this particular idea, around 1955-56, several legislation came into picture called as codification of the Hindu laws. Now in all of these 5-6 statutes, there was Hindu Marriage Act which was brought into force, Hindu Succession Act, Hindu Adoption and Maintenance Act and few other acts like this. In all of these, the term Hindu was defined as a means and includes person following Hinduism, or it can be Jainism, Buddhism, Sikhism. All of these, Jain, Sikhs, Buddhists, Hindus were all called as Hindus under the act. So this act applied to all these category of these religions. As far as the Christians were concerned, in 1925 itself, there was Indian Succession Act. And under the Indian Succession Act, they had said, because it was applicable to Indian Christians, they had to make their own law because several of the Anglo-Indians, that is Britishers who had put their foot here in India, had amassed a lot of wealth in their personal capacities also. Even as lawyers, when we try to do some of the title reports in the old Bangalore cantonment area, and if we have to go for the way of flow of title of property for more than 60 years, virtually we will find an Anglo-Indian name who would be owner of a property, and then before they go to England, they would have sold that particular property to one of the Indians and they would have gone. So most of the Britishers, when they were also having lot of properties in India. So for the regulation of their own, Indian Succession Act was made. The Parsis are also now governed under the Indian Succession Act of 1925. But Hindus and Muslims maintained their own personal laws of one or the other. Dharma Shastra here and the Hadith, Quran there, on the manner in which they would own property, inheritance, etc. for the regular, all of these purposes. So codification of Hindu laws happened, and they said from now on, everybody will only be governed by these acts. So whatever might have been written in several texts of Dharma Shastra, that will not be accounted for. Only as to what is given here will be accounted for. And literally after this, although various aspects of what was there in the Dharma Shastra was only taken into codification, in fact Dr. P.V. Kane has also contributed greatly to the codification of Hindu laws, and he was a member of parliament in the Rajya Sabha at that point of time, and he has also put in, and certain reforms also came, because under Dharma Shastra we don't see the concept of bequeath and will, but this concept of will, that even in my lifetime I could will away my property to anybody, all of these were brought in under the Hindu Succession Act. Our acts did not make, the Dharma Shastra had not made clear differences between co-personary property and self-acquired property. Those differences were made under the Hindu Succession Act. Earlier, Hindus could also marry many people and they had many wives also. So many of them had many wives. It was brought down to only having one wife here under the Hindu Marriage Act. So they said no spouse living at the time of the marriage was one of the conditions for a valid marriage. Then we also know the in order to prevent child marriages, the age was also set as 18 and 21 for the girl and boy respectively. So many of these were brought in as a form of codification. So on and from 1956, there was no necessity for a person to read the chapters of Vyavahara or others from the Dharma Shastra to see as to how it would regulate his activities, maybe in terms of adoption, marriage, and or even property at all, and he would be governed by the codification of laws. So virtually, whatever was the personal laws of Hindus came to a complete halt by virtue of the codification of the Hindu laws. Then they said that now that Hindu laws are codified, Muslim laws would also be codified, and Christian laws would also be codified. Christians are already governed, as I told you, under the Indian Succession Act. Muslim law, even to this day, have not been codified. In 1937, the Britishers had brought the application of Shariat Act. They said whatever is written in the Shariat, I told you, the Sunnah, Shariat, that particular law would be clearly applicable to all Mohammedans. That is it only has 3 sections. It applies to the whole of India. Whatever is there in the Shariat law will apply to all Mohammedans in India. And 3, if there is anything contradicting, so on and so forth, the act completes there with 3 or 4 sections. So they say whatever is there in the Sharia will apply to you. So that is the only small act of 1937. And so till date, there have been no specific laws made on that particular community, even to this day. And we will see with that particular wide gap of one, Hindus and several other religions like Jainis, Buddhists, Sikhs being regulated under a particular personal law, and the other set of Muslims not being regulated by a particular common codified law even to this day. There are certain obvious rifts that have taken place, and their rights as to what it has already been given under the constitution, how it has gone through by various judicial pronouncements starting from the Shirur Mutt case of 1954 until some of the recent judgments, and how several other laws have also come into picture, which sometimes have aided the religion, sometimes have marred the religion, will be seen tomorrow.